Hi, I'm Blake Lively, and I'm going to be taking the BuzzFeed quiz, which iconic Blake Lively character?
What looked, at first glance, like the end of a celebrity defamation war may actually be the beginning of something much bigger. The dismissal that sent shockwaves through Hollywood, the ruling that appeared to hand Blake Lively, Ryan Reynolds, Leslie Sloan, and the New York Times a decisive courtroom victory, is no longer the final chapter. It is now the foundation for an appeal that could reopen everything. And appeals are not emotional reactions. They are technical weapons. Cold. Calculated. Strategic. If the Wayfair parties follow through on what they've told the court, this will not be about headlines anymore. It will be about whether a federal judge stepped beyond his lane, expanded a legal privilege too far, and cut off a lawsuit before it ever had the chance to reach discovery. That is where the real tension lives. To understand why this appeal matters, you have to strip away the celebrity names and look at the machinery underneath. The dismissal was granted under Rule 12(b)(6), the rule that allows a judge to throw out a complaint for failure to state a claim. At that stage, the court is not supposed to decide who is telling the truth. It is not supposed to weigh evidence. It is not supposed to determine credibility. The standard is deceptively simple: to assume the plaintiff's well-pleaded factual allegations are true and ask whether those facts, if proven, could entitle them to relief. It is a gatekeeping function, not a mini-trial. That distinction is going to sit at the center of any appeal. The federal court dismissed the defamation claims tied to the New York Times article that described an alleged smear campaign. In doing so, the judge concluded that the article was protected under the fair report privilege and that there was insufficient pleading of actual malice. On paper, that sounds straightforward. In practice, it raises difficult questions about timing, confidentiality, and the limits of press protection. The fair report privilege exists to protect journalists when they report on official proceedings. If a lawsuit is filed in court, a newspaper can summarize it without fearing defamation liability, even if the allegations later prove false, so long as the reporting is fair and accurate. The theory is simple: the public has a right to know what is happening in court. The press acts as a conduit, but here's where the legal friction begins. The article at issue relied heavily on a complaint filed with California Civil Rights Department, often referred to as the CRD. Unlike a traditional lawsuit filed in a courthouse, a CRD complaint is part of an administrative process. It can begin as confidential. It does not automatically function like a civil action with causes of action, prayers for relief, and judicial oversight. Under California law, there are strict confidentiality provisions governing the agency's investigative process. Information gathered during investigations is not meant to be aired publicly before the agency determines whether claims have merit. So the appellate question becomes sharp: can a document that is confidential at the time it is provided to a newspaper be treated as a public official proceeding for purposes of fair report privilege? If the complaint was not yet a public judicial filing, does the privilege attach? And if it does not, did the judge effectively expand the scope of the privilege by relying on persuasive authority that state courts themselves do not treat as binding? The ruling cited an unpublished California appellate decision as persuasive support. That move, while not forbidden in federal court, is controversial when used to predict how a state's highest court would rule. Under what is known as the Erie Doctrine, a federal judge applying state law must make an eerie prediction about how the state Supreme Court would interpret that law. But federal courts are expected to tread carefully. Expanding a privilege, especially one that shields media organizations from defamation liability, based largely on an unpublished state case, can be seen as bold. Or risky. Appeals courts tend to be wary when lower courts create what looks like new law under the banner of prediction. The distinction between clarifying a narrow procedural nuance and broadening a substantive immunity is enormous. If the fair report privilege traditionally attaches only after an official public filing, and if confidentiality statutes are designed to prevent exactly this kind of pre-filing exposure, an appellate panel could ask whether the district court moved too far, too fast. There is also the question of with prejudice. When a complaint is dismissed with prejudice, it is terminated permanently. The plaintiff is not allowed to amend and try again. Courts often reserve that remedy for situations where amendment would be futile, where no additional facts could cure the deficiency. But at the motion to dismiss stage, plaintiffs are frequently granted leave to amend, especially in complex defamation cases involving layered factual disputes. By cutting the claims off entirely, the court effectively decided that no discovery, no internal emails, no further factual development could ever establish actual malice or defeat privilege. That decision will not go unnoticed on appeal. Actual malice, as defined by the Supreme Court in New York Times v. Sullivan, requires proof that a statement was published with knowledge of falsity or reckless disregard for the truth. It is a high bar. But it is also a fact-intensive inquiry. Courts have repeatedly recognized that evidence of actual malice often lies in internal communications, drafts, editorial discussions, and decisions about what to include or exclude. Those materials are rarely available before discovery. Dismissing a claim at the pleading stage because actual malice is insufficiently alleged can be appropriate, but appellate courts sometimes reverse when they believe plaintiffs were not given a fair chance to uncover supporting evidence. In this case, the judge concluded that denials from the subject of an article do not automatically create actual malice, and that journalists are not required to accept a subject's version of events. That principle is well established. A reporter can publish despite denials if there is a reasonable basis for the story. But the appeal could pivot on whether the plaintiffs plausibly alleged more than mere denial, whether they claimed selective editing, contextual omission, or prior coordination that might suggest reckless disregard. Another layer of complexity involves timing. The argument that the article was drafted or prepared before the complaint became public raises suspicion but does not automatically establish wrongdoing. Newsrooms often prepare stories in advance of filings. Yet if the complaint was confidential and the newspaper received it before official filing, the source of that document becomes relevant. Not necessarily unlawful, but relevant to privilege analysis. The appellate court could examine whether confidentiality statutes should influence the privilege determination. The judge also reasoned that even if the complaint contained one-sided allegations, a party has the right to present their narrative in a complaint. That is true as far as it goes. But privilege doctrine hinges not only on the speaker's right to accuse but on the media's right to republish those accusations without liability. The difference between filing in court and leaking to press before public docketing may prove significant. Then there is procedural posture. The federal court delayed entry of final judgment pending resolution of attorneys' fees motions, which complicates the appeal timeline. Under Federal Rule of Appellate Procedure 4A, certain post-judgment motions toll the time to appeal. The Wayfair parties indicated their intent to appeal once final judgment is properly entered. Simultaneously, there are pending motions for judgment on the pleadings and summary judgment on other claims, with a trial tentatively scheduled if anything survives. Judicial efficiency arguments cut both ways. Courts prefer consolidated appeals rather than piecemeal litigation, but they also resist premature interference with trial court management. Beyond doctrine, there is institutional sensitivity. Federal appellate courts guard procedural integrity. They do not reverse lightly. But when they perceive that a district court may have short-circuited the adversarial process, particularly in high-profile cases where public confidence is at stake, they scrutinize carefully. Prior reversals in unrelated cases do not determine outcomes, yet patterns can influence how closely a panel reads a record. All of this unfolds in a jurisdiction known for strong press protections. New York federal courts are historically protective of journalistic freedom, recognizing the chilling effect that expansive defamation liability can create. That cultural backdrop matters. An appeal that appears to threaten media breathing space faces headwinds. Conversely, an appeal framed as a narrow procedural correction, focused on premature dismissal and overextension of privilege, stands on firmer ground. What makes this moment volatile is not certainty of reversal. Appeals are uphill battles. The standard of review for a Rule 12(b)(6) dismissal is de novo, meaning the appellate court reviews the legal conclusions fresh, without deference. That benefits the appellant. But factual plausibility determinations still receive contextual respect. The real leverage may lie in the with prejudice aspect. Even appellate judges inclined to protect press freedom sometimes prefer remanding for amendment rather than endorsing a permanent bar at the pleading stage. If the dismissal is affirmed, the victory becomes structurally solid. If it is reversed or remanded, the case reopens, discovery proceeds, and the narrative shifts dramatically. The difference between finality and renewed litigation is enormous, financially, reputationally, strategically. For now, what exists is intention. An announced plan to appeal. A signal that the fight is not over. Appeals transform courtroom defeats into new arenas. They are not retrials. They are legal audits. And in this instance, the audit will focus on three fault lines: the scope of fair report privilege, the sufficiency of actual malice pleading, and the propriety of dismissal with prejudice before discovery. Not with celebration, but with a procedural clock ticking toward the appellate docket. In Part 2, the lens will widen beyond the New York Times to examine the implications for the remaining defendants, the anti-SLAPP fee battle, and how a reversal could reshape the entire power balance of this $400 million war. Just about legal doctrine, they are about who gains power, who loses control, and what happens when a case that looked buried suddenly finds oxygen again. The fight does not end with the New York Times. In many ways, that was only one flank of a much broader battlefield. There are still claims involving Blake Lively, Ryan Reynolds, and Leslie Sloan. There are still attorneys' fees motions pending. There are still procedural decisions hanging in the air that could change the trajectory of everything. And looming over all of it is the anti-SLAPP issue, a mechanism designed to punish lawsuits that are deemed strategic attempts to silence speech. Anti-SLAPP laws are powerful. If a court finds that a claim targets protected speech and lacks merit, the defendant can recover attorney's fees. That is not symbolic. In high-profile litigation involving major firms, those numbers can be enormous. The stakes escalate fast. So when the Times argues that the case was frivolous and that fees should be awarded, it is not just defending itself, it is attempting to flip the financial pressure back onto the plaintiff. But here is where procedural timing becomes critical. The Wayfair parties have argued that the court should not move forward on summary judgment or fee awards while an appeal is pending or imminent. Why? Because if the appellate court later reverses the dismissal, the entire foundation for those fee claims shifts. Awarding fees based on a dismissal that might not survive review risks creating exactly the kind of judicial inefficiency appellate courts try to avoid. This is not abstract. If summary judgment is granted and fees are ordered, and then months later the appellate court vacates the dismissal and remands for further proceedings, the trial court would be forced to unwind significant rulings. Appeals courts dislike procedural whiplash. That is why arguments about staying proceedings until appellate review is resolved carry real weight. Then there is discovery, the phase that never happened for the defamation claims against the Times. Discovery is where litigation becomes dangerous. It is where internal emails surface. It is where communications between publicists, legal teams, and journalists can be subpoenaed. It is where narratives are tested not by press statements, but by metadata, drafts, and timestamps. The central strategic complaint in this appeal is that the dismissal cut off discovery before it began. The argument is simple: intent cannot be fully evaluated without examining internal communications. Actual malice is about state of mind. State of mind often hides in documents. By ruling at the pleading stage that no amount of discovery could establish malice, the court effectively predicted the outcome of evidence that had never been reviewed. Appellate courts are cautious about that kind of prediction. They understand that defamation law must protect press freedom. But they also recognize that the pleading stage is not meant to be a substitute for evidentiary development when plausible allegations exist. The tension lies in determining whether the allegations were indeed plausible or merely speculative. Beyond the Times, the appeal could ripple into claims involving Reynolds and Sloan. While the legal standards differ, the broader theme remains consistent: whether the court resolved factual disputes prematurely. If an appellate panel senses that the district judge weighed credibility, even subtly, rather than simply testing the sufficiency of allegations, that becomes fertile ground for reversal. Another dimension involves the confidentiality structure of the CRD process itself. California's statutory framework was built to prevent unverified accusations from becoming public spectacles before investigation. The argument on appeal may frame the issue not as anti-press, but as pro-process. If administrative complaints can be strategically publicized before official filing and then shielded by fair report privilege, the confidentiality scheme becomes hollow. That is a policy question layered beneath the technical analysis. The appellate court will not rewrite policy broadly, but it may consider whether the district court's reasoning effectively undermines legislative intent. Confidentiality statutes are not decorative. They exist to balance reputational harm against investigatory needs. If a federal ruling dilutes that balance, state law interpretation becomes contested territory, and then there is optics. Appeals courts do not rule based on public controversy, but they are acutely aware of institutional trust. If litigants argue that the dismissal creates the appearance that certain entities receive heightened protection, the appellate judges will examine the record carefully to ensure neutrality. They will ask, did the district court follow existing law, or did it stretch doctrine to reach an expedient result? The with prejudice element again becomes pivotal here. Even appellate judges inclined to affirm dismissal may question finality without leave to amend. In complex defamation litigation involving evolving factual records, courts often allow plaintiffs at least one opportunity to refine allegations. Denying that opportunity signals strong judicial confidence that amendment would be futile. That confidence must be defensible under scrutiny. Let's talk about potential outcomes. If the Second Circuit affirms the dismissal entirely, the legal war narrows dramatically. The Times remains shielded. Anti-SLAPP fee exposure intensifies. The narrative of victory hardens into precedent. If the appellate court reverses on the privilege question, the case reopens against the Times. Discovery begins. Internal communications become discoverable, subject to protective orders and journalistic privilege arguments. The litigation timeline extends significantly. If the court affirms dismissal but vacates the with prejudice aspect, the plaintiffs receive a second chance to amend. That may be the most balanced outcome, protective of press doctrine, yet cautious about procedural finality. If the court remands on actual malice pleading, even without disturbing privilege analysis entirely, the effect is similar: renewed litigation and leverage shift. There is also a scenario where the appellate court narrows its decision carefully, addressing only technical aspects of timing and judgment entry without reaching the broader merits. Appellate courts sometimes prefer incremental corrections rather than sweeping pronouncements. Meanwhile, the anti-SLAPP fee battle hangs in suspense. If proceedings are stayed pending appeal, financial pressure pauses. If not, fee determinations could proceed, adding another layer of appellate complexity. One subtle but powerful factor is the de novo standard of review. Because Rule 12(b)(6) dismissals are reviewed fresh, the appellate court is not bound by the district court's legal conclusions. That gives appellants meaningful opportunity. However, appellate judges also respect district court experience and avoid second-guessing absent clear error. The persuasion burden remains heavy from a strategic standpoint. Announcing intent to appeal accomplishes more than legal preservation. It signals endurance. Litigation fatigue is real. Appeals extend timelines. They increase cost. They complicate settlement calculus. Even the possibility of reversal alters negotiation dynamics. There is also reputational calculus. High-profile cases live in parallel worlds, the courtroom and public perception. An appeal reopens public conversation. It reframes what looked like finality into uncertainty. That alone shifts tone, but make no mistake, the appeals are not easy. Reversal rates are modest. Panels are meticulous. Briefing must be precise. Oral argument, if granted, can hinge on narrow doctrinal distinctions. Emotional narratives fade in appellate chambers, statutory interpretation and precedent dominate. Still, the core appellate theme here is powerful. Was this dismissal a faithful application of established privilege and pleading standards, or was it an overextension designed to prevent a complex case from moving forward? If the appellate court believes the district court expanded fair report privilege beyond clearly established boundaries, especially relying heavily on unpublished authority, or it may rein it back. If it believes the actual malice analysis improperly resolved factual inferences, it may restore the case for discovery. If it finds no such error, it will affirm and solidify the dismissal. Everything now turns on how narrowly or broadly the appellate judges frame the issue. Is this a press freedom case? A procedural fairness case? A state law interpretation case? The framing determines the gravity, and beneath the legal mechanics lies a fundamental question about process. Litigation is designed to test allegations through structured evidence. When that testing is halted at the threshold, appellate oversight becomes the safeguard. So as this appeal moves forward, the narrative is no longer about a headline victory or defeat. It is about whether the federal rules were applied conservatively or creatively. Whether confidentiality statutes were respected in spirit as well as letter. Whether dismissal with prejudice was a necessary conclusion or an accelerated exit. The coming months will reveal which interpretation prevails. What is certain is that the war is not over. It has shifted arenas, from district court to appellate chamber, where the arguments become colder, sharper, and more technical, and in high-stakes litigation, technical often determines everything.